Recording from our respective locations, I'm Matthew Huffman, Public Affairs Director at MCADSV, and this is Momentum, a webcast produced by your coalition, connecting advocates across our state. In this episode, I am going to be chatting with Emily Love, our research fellow for the summer. So, Emily, welcome to Momentum.
Thanks, Matthew.
Yeah, really excited to have you with us today. One, just to be able to introduce you to our larger membership, but also because we're going to be talking about Title IX, and that is a very particular public policy area where I have a lot of interest. I've done a lot of research, and so I'm excited to have your expertise brought into the conversation today.
Thanks so much. I'm glad to be here.
Yeah. So just to give folks an idea about who you are, I was going to let you introduce yourself, kind of give us some background of who you are and how you came to the coalition.
Sure. So my name is Emily Love, and I am working as a legal research fellow with MCADSV. I'm currently, I just finished up my second year of law school, and I'm going into my third and final year. Prior to that, I spent about 5 years working at the University of Missouri in Title IX programs as a Deputy Title IX coordinator, as well as a Director of Administration for the Department of Diversity, Equity, and Inclusion. And I'm super excited to be back in the nonprofit world because prior to the university, I worked with the Missouri Medicaid Coalition while I was getting my master's in social work at the University of Missouri. And I always think about my time working with that organization and loved it so much. And now I have the opportunity to work with another statewide coalition that is doing really good work. So glad to be here.
Yeah. Well, thanks for giving us that little bit of your background, Emily. Again, I'm excited to have you on the show with us and have you working with us this summer because you bring such a wealth of prior experience, both working at the University of Missouri system, working with another statewide nonprofit doing organizing and coalition work, coalition building, but then just with your education background in social work and law, you bring such a really fresh perspective into our work, and particularly around Title IX. So when you came on earlier in the summer, we were kind of talking about different projects we'd have you work on and really dig into the research on for us. And it was obviously a very good fit to have you start digging into these new rules from the Title IX rules change. So I was thinking, just to kind of get us started, would you give us a history of Title IX? So how it's evolved over the last 48 years.
Sure. Yeah, so I'll give a brief history. Title IX came out of the Education Amendments to the Civil Rights Act of 1972, and it prohibits discrimination on the basis of sex in schools that receive some sort of federal funding. Over the years, courts and schools have interpreted this discrimination on the basis of sex to also include gender-based violence, sexual assault, domestic and interpersonal violence. And while historically a lot of folks associate Title IX with women in sports, it's gotten a lot more attention, and our collective consciousness has changed over the time to now think of it as a response by the federal government to a sexual assault epidemic on college campuses. So in 2011, the Obama administration published a Dear Colleague letter, which provided guidance for schools to manage and respond to complaints of discrimination on the basis of sex. Prior to that, schools were doing some investigations, but there wasn't necessarily a standardized way of addressing these types of issues across public universities in the country. And the Obama administration prioritized this issue and came out with this guidance and also came out with more guidance in 2014. And 2014 was definitely the time that the University of Missouri was reckoning with its Title IX past. There were a lot of articles addressing sexual misconduct at universities. Jerry Sandusky and our own Sasha Menyukuri was featured in an ESPN article that addressed her suicide and her experiences at the University of Missouri, where she made complaints of sexual assault by other student athletes. And so that inspired and kind of caused the university to write new rules and come up with a better way of handling these types of complaints while paying attention to the rights of both the accused and the survivor. After the 2016 election, however, about in September of 2017, the Trump administration rescinded the Dear Colleague letters from 2011 and 2014 and replaced them with some interim guidance that was meant to essentially lighten the burden on universities and colleges in addressing these types of complaints. And I can talk a little bit more about that as we go on. But if you fast forward to November of 2018, the Trump administration issued new draft guidance for notice and comment. And the timing is interesting because that information was released on the Friday before Thanksgiving break. And the public comment period was set to end around the middle of January. And if you can imagine, as a college administrator, knowing that your response to something like this really does require you to talk to your students, talk to your staff and faculty, and have them weigh in on the university's position, it definitely put a burden on the university to respond. Nevertheless, they did receive, the Trump administration received like a record number of comments from across the country, the majority of which expressed praise for the past guidance and asked not to rescind the Dear Colleague letters. Most of it was pretty against this new rule, including some of the major like institutional representatives like the American Council on Education, and some other representatives. So another year and a half went by, and this May in 2020, the final rules were announced, and they have an implementation deadline of August 14th of 2020. Pretty quick turnaround amidst a global pandemic, has a lot of university administrators kind of confused and concerned. Colleges across the country are, doing their best to respond while also knowing that that's a pretty fast deadline to get your rules changed. And so as it stands right now, they are due to be implemented by August 14th.
So I really appreciate you giving that kind of foundational information and then walking through the timeline of how it's evolved over time. A couple of things that I want to lift up out of what you just said is thinking about how Title IX was originally part of the education amendments to the Civil Rights Act in 1972. And I think that Title IX is such a really good example of legislation that has had an impact in all three branches of government. So Congress passed it, and then over the years, it's been interpreted by the court system to expand it and its scope. And then just as you mentioned, in 2011, really up until now, we've also seen regulatory changes and enforcement from the executive branch. And so I think it's just a really kind of interesting piece of policy to look at and how it can be involved in so many different areas of our government and in our policy work.
Definitely, definitely.
So So thinking about that and just how expansive and comprehensive it is, I think really underscores the difficult position that universities are in now whenever it was such a tight turnaround of the proposed rules change and providing any open comment, um, which we did on behalf of MCA DSV and member agencies and some of our allied partners in higher ed. Um, and it was amazing to see the record number of comments submitted there. But then, once the administration finally released these new rules, there is such a really tight turnaround for universities to think about, okay, now that you've worked really hard for a decade to come up with these comprehensive policies and procedures for your campus, rewrite those in order to have your campus ready for school to reopen in the fall amidst a global pandemic, amidst budget cuts. So yeah, I want to give voice to the difficult position that I know campuses are in right now.
Yeah, I think that's spot on. And there are also so many unknowns that I think university administrators are watching. There are lawsuits out of, I think, at least 18 states asking for this to be put on hold. There are a lot of issues about enforcement and how much will the Trump administration enforce the new rules, knowing that this will actually create less cases reported to universities for them to even investigate. So I think like with everything with the pandemic and this year, there's so many uncertainties that it's pretty hard to make any decisions at this moment without thinking the what ifs of what if this disappears after the 2020 election and all of these things that are changing. So I definitely feel for university administrators and college activists for sure.
I really appreciate you giving the both and perspective there, that it's a difficult time for university administrators and student activists because there are so many unknowns, and we have institutional change and we have social change, and one can certainly move more quickly than the other, but they really do have to work in combination together. And you're absolutely right. It puts both of those in a really difficult position right now.
Yeah, and I mean, the federal government doesn't necessarily have to be involved in making universities more accessible and encouraging students to be able to finish their education, but they're a great partner in that. So it would be ideal for them to be promoting some of the Title IX changes that I think we've heard from student activists. But I think that universities too will still have the pressure from their students to maintain the infrastructure that they've built around Title IX and to continue to take these issues seriously, even if the federal government is successful in rescinding all of these rules and kind of rolling it back.
Yeah, that's a really good point. I think that, at least from my perspective of working with Missouri universities, they're really proud of what they've been able to accomplish over the last decade. And so it doesn't necessarily mean they have to just throw out all of that work, because certainly students are much more involved and educated on Title IX now and are interested in holding these institutions accountable.
Yes.
And I find that also really encouraging because at the coalition, we have a really strong stance that we defend Title IX because it is a prevention-based policy. And at its very heart, it's a civil rights issue that seeks to bring equity into education. And so I think that, yeah, there are a lot of Missouri-based institutions, a lot of Missouri student activists who won't let it go away.
That's right. I think you're right.
So So let's take a step back and chat for a bit about um, how these changes came to be and why there was a push from the current administration to really change the rules around how universities implement Title IX.
Sure. So yeah, if we've talked about how college activists and a lot of folks across the country have um, been supportive of the Title IX changes of the Obama administration. So why change them? Well, the answer comes from some of the criticisms that have been there since 2011, 2014. The primary issue being concern over due process rights and procedural fairness for the accused. And a lot of attention has come to concerns with whether students who are accused of sexual misconduct have an opportunity to review the charges in front of them, whether they have a good enough opportunity to defend themselves, and whether the process was fair to them. And the DeVos administration paid a lot of attention to groups that were coming to them with these types of concerns, and cited due process concerns as one of the major reasons why they wanted to rescind some of the Obama era guidance. And tied in with that as well is this notion that false reports, false accusations are prevalent and can really destroy people's lives. And while it's true that a false accusation could destroy someone's life, we know from research that false accusations are pretty rare. So the emphasis on that as a reason to change all the rules, I'm not sure I totally agree with. Another reason is this general attitude that universities are over enforcing the personal lives of students, that there's just in general an over enforcement of things related to sexual harassment, sexual misconduct, that universities are too involved in the sex lives of students is sort of a perspective that I've heard, and just wanting universities to get out of this area where they think it's more appropriate for the criminal justice system to take a role. And finally, one of the biggest reasons that they have said that they've rolled them back is to reduce the burden on colleges and universities, like I mentioned earlier, and it will, but at the same time, a lot of these public institutions are asking them not to roll back the rules. So it's an interesting situation for sure.
Yeah, yeah, it's an interesting situation that we find ourselves in at the moment. And I'm kind of curious to hear your perspective on the way that we've heard so much conversation around due process. And I think there's been some narrative about how universities run kangaroo courts, which I'm going to put in air quotes there. And that it's really not something universities, just as you said, should be involved in, and it should be a matter left to the criminal justice system. But we also know there are a lot of reasons why survivors of sexual assault, sexual harassment don't want to go through the criminal justice system. And so I'm curious to hear your perspective of, why would a student prefer to go through the university process as opposed to the criminal justice process outside of campus entirely?
Yeah, so I think if I can go back to the ultimate reason why we have these rules, I think the narrative has kind of shifted to see this as a little bit of a kangaroo court or a witch hunt, trying to find all of the people who have violated the rules and make sure that they're disciplined and held accountable. But really, what Title IX is based in is the accessibility of the educational experience for the survivor. And a lot of the reason why policies and procedures are written in the way that they are is in an effort not to seek to punish or to seek to kick students out of school, but really to make sure that the students who are impacted by this very real issue are getting the resources that they need. And because college campuses have that kind of responsibility and access to students in general, and are required to have a lot of resources, it makes a lot of sense for them to be connected to survivors and be connected to students who have experienced sexual harassment, knowing that that may be the one connection to an institution that that student has. And that is an institution that's kind of meant to look out in a way for the students. And so criminal justice system, of course, has a similar role, but one of the biggest issues is that a lot of these cases don't necessarily there's not enough evidence for a beyond a reasonable doubt standard, which is required in a criminal proceeding, or it doesn't necessarily rise to the level of a crime. And the university has a right and may do so, may choose certain behaviors that are unacceptable on the college campus. And they don't necessarily have to rise to the level of a crime. And so it's really a way to address a widespread issue that just isn't handled, isn't preferred by survivors in general, like you said, with the criminal justice system. It's a lot more intimidating, I think, and really what I tell people about Title IX is that, you know, the Title IX offices are doing their job as if a student comes in and gets some resource, whether that's a counseling referral, whether that's an adjustment to their schedule, an opportunity to turn in a late homework assignment. These are the kinds of things that our Title IX offices are doing for students to help them stay in school. And I think that the notion that it's kind of that the Title IX offices are maybe out there to get the perpetrators is a little can be a little misleading, and certainly isn't the primary reason why the rule exists.
Thank you for walking through all of that. And I really want to jump back just a moment to whenever you said that universities have the right to do this. Because I think that's such a really important aspect that is often lost in the conversation. Universities have the right to determine their code of conduct for students, staff, faculty, and saying it is not part of our university conduct for anyone to perpetrate gender-based violence, regardless if that is sexual harassment, stalking, sexual violence, dating violence. These are behaviors not tolerated at this institution. They have a right to say that, absolutely, and enforce it. But yeah, it does begin to get really muddy whenever part of that narrative starts coming down into, well, does that provide due process? Are we really providing fair and equitable opportunities for those accused? And so no, it does get really muddy, but I appreciate you kind of walking through those layers.
Yeah, and I also want to mention that the sanctions between the criminal justice system versus the university procedure are so different. It's, yes, students could be expelled or suspended from the university if they are found responsible of a policy violation, but that is the worst thing that can happen. And oftentimes that sanction does not come about. It's pretty rare. And so I think when you remember that as well, it's a reminder that we want, students to be able to be successful here, even if they are accused. And I think that's just important to remember.
Yep. Yeah, absolutely. Well, let's talk a bit about some of the changes really specifically that are being rolled out in these new rules. So you took on the task whenever you joined us of reading through the, is it 1,200 pages, I think, that were released in the new rules document?
Gosh,
Um,
I don't know. I'd have to look back.
it was it was a very high number of pages in this full report, and I don't remember exactly offhand either. But you took on that task for us of combing through them, and then did a lunch and learn for all of our staff on it. And so you identified three major changes in these rules. Can you kind of talk a bit about what they are?
Yeah, definitely. So a lot of changes. The first one is one of the first one I'll talk about is pretty major, and that is that the new rules narrow the definition of sexual harassment. And I always find it so interesting in policy work that one word can really change everything. And the word in this particular issue is that is an and versus an or. And so now unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to education. That is the new rule, whereas it used to be severe, pervasive, or objectively offensive. And you can kind of be creative in coming up with examples of what that might miss. And the one that comes to mind the most for me is a one-off. So one very severe comment, perhaps a sexual innuendo, something that is not necessarily pervasive and has never happened before, may not necessarily count as sexual harassment anymore. And alternatively, you've got the situations where there's a pervasive issue that's really minor, and maybe it's just these subtle undertones of whether it's a sexual innuendo or some gender-based comments or biases, something that's happening over and over and over again, but that isn't so severe that, you know, that it rises to this level. And so there will be a lot of situations, and I'm thinking especially for staff and faculty, that there just simply isn't sexual harassment by this definition. And yet you can imagine in both of those situations, there being an issue around whether it's causing harm and preventing someone else from achieving their educational goals. And the second big change is that the new rules limit the jurisdiction and scope of university involvement in some cases. And so they've lessened the obligation for universities or taken away the obligation for universities to investigate incidents that happen off campus, and off campus as well as happening outside of any educational program. And study abroad programs as well. The rules even say if it happens abroad, it doesn't necessarily have to be investigated by the university, even if it involves university students. And that creates some holes that there will be students on campus who have been harmed by something that the university can't necessarily even look into. They can still get resources. I will emphasize that. That's always an important thing. Another implication of this is that university won't necessarily be able to move forward with an investigation if they become aware of one perpetrator perpetrating multiple victims. And perhaps each of these situations is not very severe or not as pervasive as would be necessarily required. But looking at as a whole, the university noticing this pattern, under the Obama administration guidance, the university had an obligation to deal with that, even if none of the victims said, I want to move forward with an investigation. If the university knew that there's one person or a group of people that are consistently showing up, that something needs to happen. There has to be some sort of intervention. And right now that is a little bit taken away, I guess. There is also a change to the timelines of how long it's going to take these cases to be completed. And now it's simply a reasonably prompt timeline, which is pretty open-ended. And got some action here with my cats.
The joys of working and studying from home.
Yes, of course. And so while I would never think that any Title IX coordinator or people in that position would drag their feet on a case or an investigation, I think that the new rule in some ways incentivizes campuses to take their time. Maybe there's a student who's been accused and it's that student is almost about to graduate, and the office maybe doesn't take much action, knowing that in a matter of months, the student will no longer be a student, and the university can kind of not necessarily investigate fully. I hesitate to say that anyone would do that intentionally, but I think we have to acknowledge that the rules could incentivize that. And colleges as well, going back to sort of the reason why Title IX exists, these new rules make it so that colleges don't have to designate most employees as mandatory reporters. And I do think that a lot of schools have evolved on this issue. I know the University of Missouri kind of started with everybody's a mandatory reporter, and over time has relaxed it in a mindful and intentional way. And I think that that's great. I personally am pleased with how that's come about. But the reason the mandatory reporter even is such an important part of the Obama administration's guidance is that, again, more students who have experienced something like this now are being reached out to by the university, being given a list of resources, being offered a chance to come in and tell their story, being offered a chance to engage or not engage. And it isn't necessarily a bad thing to have all of these mandatory reporters. So I think that's one that I could be argued a few different ways. And then lastly, something that has been kind of in contention since the Obama guidance is the requirement now of a live hearing. And a lot of universities do already have hearings, but the new rules require that cross-examination happen, that it is allowed, and that all witnesses and complainants must participate in order for their statements or whatever evidence they have for it to be admitted for the hearing panelists' consideration in a finding of responsibility. And you can imagine that this notion that you would be cross-examined would definitely persuade some complainants and witnesses, persuade them to not participate. So I think we'll see a lot less participation in these hearings. And we will also see some interesting quasi-judicial changes. Like, it's interesting you brought up kangaroo courts, because to me, based on my experience, these new proceedings look way more like a kangaroo court than they have before. And so just to unpack that a little bit, every student is allowed to have one advisor. And this advisor can be anybody the student chooses. It can be their parent. It can be a staff member they have a relationship with. It could be an attorney that they hire. And, you know, a lot of universities require that students are afforded an advisor if they don't have one. However, a lot of advisors are volunteers. They care about the student. They care about making sure that the student understands the policies. And so they're doing this in their spare time, as opposed to somebody who maybe can afford to hire a lawyer and have them invest a lot more into the case. And so you're going to see some disparities between students who have an advisor that's an attorney versus not. And that will definitely come into play during cross-examination, as you can imagine. And, you know, training advisors to cross-examine I certainly wouldn't want to take on the task of teaching folks that extra job on top of their regular job. And also, I haven't mentioned the hearing panelists themselves. The staff and faculty who sit on these hearing panels, again, are volunteers, and they're well trained. They go through training on how this is supposed to work, how it's supposed to be fair, and they're going to be put in situations where there normally would be a judge there to kind of handle the behavior of the advisors or the attorneys, and instead it's going to be hearing panelists who aren't necessarily trained to be judge-like. And so it definitely, I think introducing that quasi-judicial aspect to the hearings is going to reduce the number of hearings, certainly. And I think the hearings that happen will be very burdensome, and they will require a lot of resources, a lot of training, a lot of talking it out beforehand. And again, I think they will become increasingly rare. So those are the three main changes that I highlighted in the Lunch and Learn, and wanted to share with everyone today.
Yeah, and I really appreciate you doing that too. Like I said, you took on the incredible task of reading through all of those pages and then synthesizing it down for us in a really manageable way. You know, a couple of things that really stand out for me in what you had said. One is thinking about the limited definition and scope of sexual harassment now, and thinking about it from the criminal justice perspective. Sexual harassment is not necessarily a chargeable crime.
Right.
And so we'll now see a huge gap there in individuals who experience sexual harassment and might not really have a good way of accessing support and justice, and even, you know, preventing it from happening to other folks. So that's a huge gap. Totally.
And I'm glad that you mentioned preventing it from happening to other folks, because that too is such an important part of Title IX. There's a lot of situations where a student who's accused did not necessarily know the impact or the seriousness of their conduct. And I think it's in my experience, it's been amazing to see some of the cultural changes around talking about sexual harassment and even like stalking, and knowing that there's not always a terrible intent behind it, but without any sort of, I don't want to say a remedial, without any sort of response, that behavior may continue and will likely continue until someone else corrects it. So.
Yeah, well, and then your perspectives on now the process being quasi-judicial in nature, I think it takes away that heart of Title IX being about equity. So just from an equity standpoint, and being able to have advisors present, I can see so many ways that this could turn into a situation where a student who has more access to resources, can hire an attorney. And the other student who might not have those same resources, they are still entitled to have an advisor there, but but where are they finding that person? And just as you were saying, if many of the people involved are volunteers, then it's not an equitable process. And you're right, it's going to take a lot of resources and time and energy to really put all of these new policies into practice.
Definitely. The equity issue between the advisors is serious. And I think too, if your advisor is an attorney and they're operating in this entirely different system than civil procedure or criminal procedure, they aren't even necessarily more powerful, like as far as what they're able to do for their student than an advisor who's a non-attorney. But then you have the issue of like an attorney acting like an attorney in a situation where maybe it's more important to be an advocate or an advisor. And that's more of the role that they are supposed to take on. So yes.
Well, we've been talking about it a bit already, but I want us to kind of process through some of the potential impacts of this, what it will mean for survivors, what it can mean for campuses, what it can mean for advocates at our member agencies. And so, yeah, let's kind of dig into that a little bit. From your perspective, what are some of the major impacts that this will have?
Yeah, I think the biggest one is less participation in the process. I think the new rules, one, a lot of cases that are reported aren't necessarily going to move on into the investigation. But if they do, students who maybe are intimidated by the process may opt out, and especially I'm thinking of witnesses, friends of either party who were there the night that the incident occurred and have information that would help the hearing panel decide if a violation occurred, but saying I don't want to participate. And I think that is definitely going to affect universities, and I think there will be less reports in general. We already know that a lot of these cases, I mean, based on climate surveys, climate studies at all universities, these are pretty underreported issues, and I think we will see even less reports coming through, especially if the universities don't take really intentional and active steps to communicate to the university community that even though these rules are changing, that they still take sexual violence and sexual harassment complaints seriously and will address them. And so making sure that universities' communication strategies are in a way still supporting some of the background of Title IX. I think that'll be important. Otherwise, yeah, I think you'll see a lot less reports. And I know in our work, we both can imagine how traumatizing it would be for a victim or a survivor to be cross-examined in this hearing, being in the same room with their perpetrator, going through this re-traumatizing type experience. Even if there are some changes that they can make, like having them call in or be in the other room during the hearing, there are ways to mitigate some of the effects, but ultimately, a lot of students want to go through an informal process where they don't have some arduous hearing that they have to go through. And so I think that can be pretty harmful. And just in general, I think we have to ask, is justice really served here? And will justice be served with these new rules? And I think a lot of students might see the new guidance as reducing their access to justice.
I really agree, Emily, and something that you said that I really kind of picked up on and have been thinking about as well, um, is the re-traumatization aspect of it. And if you're a survivor who is still on campus with the person who has caused harm against you, yeah, it's not likely that you're going to want to have to go through a trial of sorts and to have to relive that and to be cross-examined. And it's that very reason that many survivors often don't want to go through the criminal justice process, that it's a long process. You have to continue to relive your story. You have to be questioned on any number of things that shouldn't even be an aspect of your assault. Um, and so, yeah, I agree with you that that's a major concern, is just the impact of trauma that it will have on folks now.
And I think a lot of student survivors that I've interacted with too, they feel this sense of obligation to protect other people, and they feel, and sometimes feel pressured to go through another traumatizing experience if it means that they're protecting other students. And I think that's a lot to put on them. And I think that there are much more creative ways that uh, universities can intervene and remedy the effects of the discrimination without requiring a student to go through such an arduous process.
Yeah, I couldn't agree with you more. I think the burden now placed on student survivors is going to be incredibly high.
Mm-hmm. Yes.